Australian nationality law determines who is and who is not an Australian citizen. The status of Australian nationality or Australian citizenship was created by the Nationality and Citizenship Act 1948, which came into force on 26 January 1949. The 1948 Act was amended many times, notably in 1973, 1984, 1986 and 2002. The Australian Citizenship Act 2007 replaced the 1948 Act, commencing on 1 July 2007. On 13 December 1973, Australia acceded to the 1961 Convention on the Reduction of Statelessness and to the Convention relating to the status of refugees. Australian citizenship law is administered by the Department of Immigration and Border Protection, which can issue certificates of citizenship on naturalisation or on request, provide other proof or evidence of Australian citizenship. Australian passports are issued to Australian citizens by the Department of Foreign Affairs and Trade. In Australia, the terms nationality and citizenship can be used interchangeably, but the term citizenship is more commonly used, while nationality is more commonly used on official documents and forms. A person may acquire citizenship automatically by operation of law, or by application after a period of residence in Australia. The process of acquiring citizenship by application is referred to as naturalisation. History of Australian citizenship. Until the passing in Australia of the Nationality Act 1920, Australia's nationality law, like that of other Commonwealth countries, was governed by the English common law concept of a British subject. The idea that there was such a thing as an Australian nationality as distinct from a British one was considered by the High Court of Australia in 1906 to be a novel idea to which it was not disposed to give any countenance. The British Nationality and Status of Aliens Act 1914 codified the common law rules. Australia followed with the passing of the Nationality Act 1920, which codified the concept of a British subject in Australia, effective from 1 January 1921. In general, the principles of the 1920 Act and subsequent amendments followed United Kingdom legislation, although there were some differences that could lead to a person being a British subject solely under Australian law. The 1948 Commonwealth Heads of Government meeting decided to make major changes in nationality laws throughout the Commonwealth, following Canada's decision to enact its Canadian citizenship law effective January 1, 1947. Until then, all Commonwealth countries, with the exception of the Irish Free State, had a single nationality status of British subject. It was decided at that conference that the United Kingdom and the self-governing dominions would each adopt a separate national citizenship, while retaining the common status of British subject. The Nationality and Citizenship Act 1948, which came into force on 26 January 1949, gave effect to that arrangement and created the concept of Australian nationality while continuing to be British subjects. However, the status of other British subjects in Australia differed from the status of those who were not British subjects. Aborigines became Australian citizens under the 1948 Act in the same way as other Australians. The same applied to Torres Strait Islanders and the indigenous population of the territory of Papua. The relationship between Australian citizenship and a citizen of the British Empire or Commonwealth continued to evolve. In 1986, the Australia Act 1986 severed almost all of the last remaining constitutional links between the United Kingdom and Australia. Subsequently, in 1988, for the first time, the High Court ruled that anyone who was not an Australian citizen, whether or not a subject of the monarch of the United Kingdom, was an alien. The 1948 Act was amended many times, notably in 1958, 1973, 1984, 1986 and 2002. In 1973 the 1948 Act was renamed the Australian Citizenship Act 1948. On 15 March 2007, the Australian Citizenship Act 2007 received royal assent and replaced the 1948 Act, commencing on 1 July 2007. Nationality law changes. The principal milestones in the development of Australian nationality law have been 1920. Nationality Act 1920 codified the concept of a British subject, as defined under Australian law, effective 1 January 1921. 1948. Nationality and Citizenship Act 1948 created the concept of Australian citizenship, and came into force on 26 January 1949. Australian citizens continued to also be British subjects. 1958. On 8 October 1958, provisions which caused some naturalised Australians resident outside Australia and New Guinea for 7 years to lose Australian citizenship were repealed. 1973. Significant changes to the law implemented by the Whitlam Labor government, mostly effective on 1 December 1973. Distinction between migrants from Commonwealth and other countries abolished. The previous residence requirements of 1 year and 5 years to become Australian citizens replaced by a common residence period of 3 years, but with a 6-month transition period. Age of majority for citizenship purposes reduced from 21 to 18. The 1948 Act was renamed the Australian Citizenship Act 1948. 1975. The Papua New Guinea Regulations 1975 provided that any Australian citizen becoming a citizen of Papua New Guinea at independence on 16 September 1975 should lose Australian citizenship. 1984. The Australian Citizenship Act 1984 became effective on the 22nd of November 1984 and made significant changes, including that Australian law would no longer regard Australians as British subjects. British subjects in Australia who were not Australian citizens became permanent residents. Australian passports are only to be issued to Australian citizens. At the same time, the residence period for naturalisation was reduced from 3 years to 2 years. 1986. The Australian Citizenship Act 1986 provided that children born in Australia on or after 20 August 1986 would only be Australian citizens if at least one parent is an Australian citizen, a permanent resident. 1994. From 31 January 1994, new citizens have been required to take a pledge of commitment to Australia instead of an oath to the Queen of Australia. 2002. From 4 April 2002, Australians becoming citizens of other countries by voluntary act no longer lose Australian citizenship. 2007. On 1 July 2007, the Australian Citizenship Act 2007 replaced the 1948 Act. Many Australians who had lost citizenship under the 1948 Act, and the children, are given access to Australian citizenship. The residence period for naturalisation was increased from 2 years to 4 years, with a 3-year transition period for existing permanent residents, and a citizenship test was introduced. Rights and duties. Rights. Australian citizens enjoy the following rights: entitlement to an Australian passport and to Australian consulate assistance overseas, entitlement to re-enter Australia at any time without any immigration restrictions, immunity from deportation, entitlement to register overseas-born children as Australian citizens by descent, entitlement to seek employment by the federal government or in the Australian Defence Force, entitlement to vote and stand for public office. Most states do allow dual citizens to stand for state parliaments. Duties. The following duties are expected of Australian citizens: obey the law, pay tax, defend Australia should the need arise, enroll to vote and vote at all elections and referenda, serve on a jury if called upon. Acquisition of Australian citizenship. The 26th of January 1949, a distinct Australian nationality, a citizenship, was created on the 26th of January 1949. Persons who had been British subjects on that date could apply to acquire the new Australian citizenship if they were born and naturalised in Australia, born in New Guinea, born overseas to an Australian father, provided they had entered Australia with permanent entry permits on or before the 26th of January 1949, ordinarily resident in Australia for the 5 years preceding the 26th of January 1949. Women who were married to Australian men and had entered Australia with permanent entry permits before the 26th of January 1949. Australian citizens continued to be British subjects. A person could acquire Australian citizenship under the law even if he or she also held or obtained the nationality of another Commonwealth country, or if they also held foreign citizenship. The Australian Citizenship Act 1984 removed the status of British subject from Australian citizenship law, with effect from the 22nd of November 1984. Citizenship by birth. A person born in Australia before the 25th of January 1949 was automatically a British subject, based on the jus soli principle, regardless of the status of the parents. Children born to visitors of foreigners also acquired citizenship by birth. Such persons need to apply for Australian citizenship, otherwise since the 20th of August 1986 they have the status of permanent resident. A person born in Australia between the 26th of January 1949 and the 19th of August 1986 automatically acquired Australian citizenship. Until the 21st of November 1984, such a person had the status of Australian citizen and British subject, but after that date the status of British subject ceased to exist in Australia. The jus soli principle was abolished from the 20th of August 1986, with persons born after that date acquiring Australian citizenship by birth only if a descendant of at least one parent who was an Australian citizen, a permanent resident at the time of birth. The definition of parenthood was tested in H.V. Minister for Immigration and Citizenship, where it was held that parenthood does not necessarily require it to be of a biological nature. A child born in Australia and who lives in Australia automatically acquires Australian citizenship on his or her 10th birthday, if the child has not been granted or otherwise acquired Australian citizenship in the meantime. This occurs automatically by operation of law, and applies irrespective of the immigration status of the child or his, her parents. Children born in Australia whose parents are stateless and not entitled to any other country's citizenship may in some circumstances be granted Australian citizenship. Citizenship by descent. Persons born overseas to an Australian citizen parent have been able to acquire Australian citizenship in the following ways. British subjects born outside Australia before the 26th of January 1949 with an Australian father became Australian citizens automatically upon entering Australia with a permanent visa. A person born outside Australia on or after the 26th of January 1949 may be registered as an Australian citizen by descent provided they had an Australian citizen parent at the time of birth, and, if the Australian parent is also an Australian citizen by descent, that parent had lived legally in Australia for a total of 2 years. A person born outside Australia or New Guinea before the 26th of January 1949 may be registered as an Australian citizen provided that person has a parent born and naturalised in Australia and New Guinea, and the parent became an Australian citizen on the 26th of January 1949. Australian citizenship by descent is not conferred at birth, and a child born outside Australia to an Australian parent must apply for citizenship. If aged 18 or over, an applicant for Australian citizenship by descent must be of good character. Children of former Australian citizens, where an Australian parent has lost Australian citizenship before the birth of a child, the child is not eligible for Australian citizenship by descent. However, such a child is eligible for a special conferral of Australian citizenship under Section 21 of the 2007 Act if the Australian citizen parent lost Australian citizenship under Section 17 of the 1948 Act prior to the child's birth. Section 17 concerned automatic loss of Australian citizenship upon naturalisation in another country as an adult before the 4th of April 2002. Children of former Australian citizens who lost their Australian citizenship under Section 18, Section 20 or Section 23 do not benefit from this concession. There is no age limit and those over 18 are eligible to apply. Citizenship by naturalisation. Naturalisation is the process by which one undertakes allegiance to a new sovereign and, often enough, sheds allegiance to another sovereign. Between the 26th of January 1949 and the 30th of November 1973, British subjects were able to apply for registration as an Australian citizen after 1 year's residence in Australia as an immigrant. There was no requirement to attend a citizenship ceremony. Non-British subjects were required to apply for naturalisation, which had stricter requirements, including a 5-year residency. The Australian Citizenship Act 1973 ended the preferential treatment for British subjects from the 1st of December 1973. For that date, the same criteria for naturalisation applied to all applicants for citizenship by naturalisation, though the special status of British subject was retained. Also from that date the age of majority for citizenship matters was reduced to 18 years, so that they can apply for citizenship in their own right. The common residence requirement of 3 years was reduced to 2 years from the 22nd of November 1984. For that date, the status of British subject was removed from Australian citizenship law, the status having been discontinued in British law on the 1st of January 1983. People who became permanent residents from the 1st of July 2007 must have been lawfully resident in Australia for 4 years before applying for naturalisation. The lawfully resident test could be satisfied by a student visa, a tourist visa, a 457 visa, but the applicant must have been in Australia for 12 months as a permanent resident. have had absences from Australia of no more than 12 months in the previous 4 years, including no more than 3 months in the 12 months before applying, have not been unlawfully in Australia at any time in the 4 years preceding application, understand the responsibilities and privileges of Australian citizenship, be able to speak and understand basic English, understand the nature of the application, intend to reside in Australia or to maintain a close and continuing association with Australia. Children aged under 18 can be included in the application of a responsible parent. The standard residence requirements do not apply to such children. There are some exceptions to the standard requirements, including children of former Australian citizens, Australian Defence Force veterans, former Australian citizens and those born in Australia, children adopted by Australian citizens, spouses and interdependent partners of Australian citizens, persons born in Papua before independence in 1975, persons born in Australia who are stateless. Those who were present in Australia as permanent residents before the 1st of July 2007 remain subject to the previous residence requirement on any application for naturalisation made before the 1st of July 2010. They must have been present in Australia as a permanent resident for a total of 2 years in the 5 years before application, have been present in Australia for a total of 12 months in the 2 years before application. In general, applicants aged 16 or over must attend a citizenship ceremony and make a pledge of commitment, except for children of former Australian citizens granted citizenship under Section 21 of the Act. Persons born in Papua before independence granted citizenship under Section 21 of the Act. Stateless persons born in Australia and granted citizenship under Section 21 of the Act. Persons with a permanent or enduring physical or mental incapacity that means the person is not capable of understanding the nature of the application, or demonstrating a basic knowledge of English, or demonstrating an adequate knowledge of the responsibilities and privileges of Australian citizenship. For the 1st of October 2007, most applicants for naturalisation aged between 18 and 60 must pass the Australian Citizenship TED, which focuses on Australia's values, history, and traditional and national symbols. Loss of Australian citizenship. Prior to the 4th of April 2002, many Australian citizens lost Australian citizenship through acquiring another citizenship, or being the child of a parent who did so. For this date onwards, the scope to lose Australian citizenship is more limited. Adult Australian citizens acquiring another citizenship between the 26th of January 1949 and the 3rd of April 2002, an adult Australian generally lost Australian citizenship automatically upon acquisition of another citizenship by a voluntary and formal act, with the following rules. The age of majority in this respect was 21 until the 30th of November 1973, and 18 thereafter. Before the 22nd of November 1984, Australian citizenship was not lost if the acquisition of another citizenship took place while the person was inside Australia. From the 22nd of November 1984, the incidental acquisition of another citizenship as the result of another activity did not cause loss of Australian citizenship. Loss of Australian citizenship still occurred even if no oath of allegiance was taken to the other country. Loss of Australian citizenship occurred even if the Queen was also head of state of the other country. It was not relevant whether the acquisition of another citizenship was reported to the Australian authorities. Section 17 of the 1948 Act was repealed with effect from the 4th of April 2002. although the repeal was not retroactive. Since 1 July 2007, former Australian citizens who lost citizenship because of the section are generally able to apply for resumption of Australian citizenship. Loss of citizenship. Children did not lose Australian citizenship by virtue of their own actions, but could lose Australian citizenship if a parent lost Australian citizenship. If the child did not have any other citizenship, it did not lose Australian citizenship. Before the 22nd of November 1984, there was only one parent for citizenship purposes, usually the father. Loss of Australian citizenship by the other parent did not affect the child's status. From the 22nd of November 1984, loss of Australian citizenship by either parent could affect the child's citizenship. However, a child would not lose Australian citizenship in this circumstance if one parent remained an Australian citizen. Loss of Australian citizenship occurred under Section 23 of the 1948 Act. Even after the repeal of Section 17 of the Act in 2002, Section 23 was left in place. It remains possible for an Australian child to lose Australian citizenship this way. However, since the repeal of Section 17, this is much less common and in general only applies where a parent is deprived of Australian citizenship, or renounces Australian citizenship under Section 18 of the Act. Under the Australian Citizenship Act 2007, in force from 1 July 2007, an Australian child no longer automatically loses Australian citizenship based on a parent's actions. However, the Minister for Immigration and Citizenship has the right to deprive a child of Australian citizenship in these circumstances on a discretionary basis. Naturalised Australian citizens. Between the 26th of January 1956 and the 7th of October 1958, a naturalised Australian citizen lost Australian citizenship if resident outside Australia and New Guinea for a continuous period of 7 years without registering annually a declaration of intent to retain Australian citizenship. This occurred by virtue of Section 20 of the Nationality and Citizenship Act 1948, which was repealed on 8 October 1958. The provision had the potential to create stateless persons. Since 1 July 2007, persons who lost Australian citizenship because of the provision may apply to resume Australian citizenship, subject only to being of good character. Australian citizens connected with Burma. Burma became independent outside the Crown's dominions on 4 January 1948. In the Burma Independence Act 1948, the United Kingdom legislated to remove British subject status on that date from any person born in Burma whose father or paternal grandfather was born in Burma, and neither father nor paternal grandfather born in a British territory, a British protectorate, and women married to men who lost British subject status by virtue of the above provision. Such persons who were domiciled in the United Kingdom or His Majesty's dependencies were given 2 years to elect to remain British. Australian legislation was not updated at the time and hence the common law applied. British subjects connected with Burma lost British subject status under Australian law only if resident in Burma. As a result, some British subjects connected with Burma acquired Australian citizenship on 26 January 1949 if resident in Australia for 5 years at the point. On 29 July 1950, the Australian Parliament passed the Nationality and Citizenship Act 1950, which removed the discrepancy between Australian and British law on the status of persons connected with Burma. As a result of the Act, Australian citizenship was lost on 29 29th of July 1950 by persons who had had British nationality removed from them under the UK legislation in 1948, and persons descended from or married to such persons. Such persons were given until the 29th of July 1952 to register a declaration of intention to remain a British subject. If such a declaration was registered, the person was deemed never to have lost Australian citizenship. Service in the armed forces of an enemy country. Section 19 of the 1948 Act stated, "An Australian citizen who, under the law of a foreign country, is a national, a citizen of that country and serves in the armed forces of a country at war with Australia shall, upon commencing so to serve, cease to be an Australian citizen." Despite being involved in a number of armed conflicts since 1949, Australia has not declared a formal state of war on another sovereign nation in that period, and hence Section 19 has not operated up to now. Since the 1st of July 2007 it has been reenacted as Section 35 of the 2007 Act. Deprivation of Australian citizenship. A naturalised Australian citizen may be deprived of Australian citizenship under Section 34 of the 2007 Act in the following circumstances: conviction for certain offences against the Australian Citizenship Act 1948 of the Migration Act 1958. These mainly involve fraud in the person's citizenship or migration application, where the person receives a prison sentence of 12 months or more for an offence committed before the person's application for Australian citizenship was approved. Deprivation of citizenship cannot occur for this reason if the person has no other citizenship. In December 2015, the Australian Citizenship Act 2007 was amended by the Australian Citizenship Amendment Act 2015, which introduced 3 mechanisms by which citizenship may be forfeited: renunciation by conduct, and expanded S35 to cover service in a declared terrorist organisation, and a new power for the minister to cancel citizenship after a person is convicted of one of a range of offences, most of which are connected to terrorism or treason, and a minister is satisfied of certain public interest criteria. The explanatory memorandum makes it clear that engaging in the specified terrorism conduct is what shows that the person has acted inconsistently with their allegiance to Australia. The loss of citizenship is said to occur by operation of law. The idea that something can be surrendered by operation of law is well established in Australian case law. See for example Bagnall v White. However, the recent decision of the full federal court in SZSSJ Minister for Immigration and Border Protection has indicated that it may be difficult for courts to avoid a conclusion that an administrative decision must be made by someone at some point, and that a minister must hold ultimate responsibility for his department's decisions. Ex-citizen visa. A person who ceases to be an Australian citizen while physically inside the migration zone of Australia automatically receives an ex-citizen visa. Under Section 35 of the Migration Act 1958, this visa ceases to have effect as soon as the person leaves Australia. Should the former citizen wish to return as a resident return visa or other permanent visa is required. An ex-citizen visa may be cancelled on character grounds and the former citizen removed from Australia. This is likely where citizenship has been revoked under Section 21 of the Act.